Welcome back to CE Family Law Conversations. I'm Lauren Copeland, Director here at CE Family Law in Brighton. And today we're tackling a topic that comes up regularly for clients and one that I think is often misunderstood, causes a great deal of frustration for a lot of people going through a separation, and that is child support. It can often feel like a maze. The system has a lot of moving parts. There are delays. There are options most parents don't know exist. And the decisions you make early on can have a real impact on your financial situation for years to come. I'm pleased to say that today I'm joined by someone who lives and breathes child support. Crystal Paduch is the founder and director of Child Support Consultants, which is based in Sydney and is a national firm, and they assist separated parents navigating the complexity of the child support system. Crystal has over 17 years of experience in child support matters, having worked at Services Australia, formerly known as the Child Support Agency, for 12 years, in which she had a variety of different roles. Crystal is often a very valuable resource to both family lawyers as well as clients who are really finding it difficult and tricky navigating Services Australia, the assessment process, and all that comes along with it. Welcome, Crystal, today.
Thanks, Lauren. Nice to be here. Thanks for having me.
So, Crystal, before we get into the details, I guess from my perspective, as a family lawyer, we often get queries and concerns about the child support assessment. What are the top, I guess, areas of concern as someone who specializes in the area of child support as a consultant do you get from clients?
Yeah, I'd say the main, or what we would call the top three
Yeah.
issues that clients have would be inaccurate assessments, collection issues,
Mm.
and incorrect or inconsistent information and advice given by the agency when they contact them.
On the topic of collection, you mentioned that there's obviously issues with collections, and I was hoping that you could perhaps expand to our listeners about what those issues that are commonly faced, how they can be rectified, any advice for people where there are collection issues, whether you're the paying parent or the receiving parent.
Yeah, absolutely. So I guess the main point to make for people newly starting out within the agency is to have realistic expectations and an understanding of what child support can and can't do in relation to collection of child support. So they cannot disperse a payment to you as the person who's eligible to receive child support until they receive it from the person who's liable to pay it. So it's not like a Centrelink payment, for example, where you get that regular, consistent payment on a regular basis. Ideally, you will, if the paying parent, the person who's liable to pay child support, pays it in a consistent manner. But if they don't, child support will not pay you until they receive it. So what child support can do is they do have some administrative enforcement powers that they can utilize if need be. So they have a bit of a process there. So they have a process of trying to contact the liable parent to try and negotiate or discuss the outstanding debt. If that's not successful or satisfactory, they'll then move on to the collection process, and that's investigating their circumstances. So what you could do if you're the person who's entitled to receive child support is provide the agency with as much information, collection information to the agency as you're aware of. So that could be where that person is working, where they may bank, so their financial institution, whether they have any assets or whether they travel overseas on a regular basis for business or leisure. Because things that the agency can do, and they will do, is they will do things like intercept tax refunds. They can put a departure prohibition order on someone to prevent them from leaving the country if they have a child support debt. They can garnish bank accounts. They can send a notice to a bank to take money from their personal bank account, or they can send off a notice to their employer to garnish their wages. So that will provide the instruction to their employer to take money for child support in line with their pay cycle and send it to child support on a regular basis. So those are the administrative powers that they will take. And if it does get to that sort of extreme level law and there's an asset identified, they can take a person to court. They can take litigation action against a person. What they can't do, they can't access at the moment. This could be changing in the future because there is an inquiry underway at the moment following a recent ombudsman inquiry into the child support system. But at the moment, they can't access company accounts, trust accounts, joint accounts. So they've got these issues. This is the problem that the agency has, is they have
Mm.
a lot of restrictions or limitations into what they are able to do in relation to collection. And unfortunately, there are a lot of people who do take advantage of those sort of loopholes, they call them, in the system at the moment
Yes.
to avoid payment.
And with these administrative powers, because often people will come to us and say, "Oh, you get their passport?" Like it's a very easy thing to do, and we will
Yeah.
obviously direct them to Services Australia and obviously to yourself to assist them in any of those issues that they may have. But I guess from my perspective, again, one of these common concerns is how fast can everything be done? And
Yeah.
so, at what point does it have to be that with Services Australia that someone doesn't pay? Is it one payment and all of a sudden you're garnishing wages? Or is it 6 weeks of payment? What's the threshold? What's the guideline?
There is a procedural guideline that they are
Yes,
supposed to follow.
yes.
They don't always follow it, but and it's not a certain amount. What happens is you are in default if you don't pay by
Yes,
the due date. So it doesn't matter how
sure.
much it is necessarily. It's if you
Yeah,
are in default, you're non-compliant if you haven't paid by the due date. So that's when they will go through that process of trying to contact you. If you're the person who owes the debt, they should be
yeah,
calling you, trying to call you. If you're non-responsive, then they'll send a letter and they'll give you time to
yes,
respond to that letter. And then if you don't respond, that's
yeah,
when they start looking. They'll start issuing, information gathering notices. They don't just go and issue a garnishee order.
yes, of
Usually they
course.
have to send off an information gathering notice first to make sure that you actually have accounts there, available money there, you're employed there, whatever it might be. They get the information first, and then
Yes.
if viable, they will then issue that order. So that's sort of the process you take. I mean, child support are not necessarily known for being overly fast with anything.
No, and that's, I
Um,
guess, the big
so
issue
you
that we
might be
often have
waiting.
is that people talk about, but how long is this going to take? And how long is this going to take? And how much time do I have to spend doing this? And they feel, it can be it can be difficult in that way.
It is. It is. Unfortunately, it is. It depends. It's case by case because you might find on your end, you might think it's quite simple. You might give all the information and say,
Of
okay, we've got
course,
enough information. You should have enough now to be able to do something with that.
you
But
should.
unfortunately, it may not be the case because, like I said, they may say, okay, someone is who has accounts with Commonwealth Bank, for example. But when
Yes,
they go and source that information, it turns out, well, it's actually a company account or it's a joint account or something like that. So they don't actually have the power or jurisdiction to access that information. They
no,
can't do anything with it.
no.
Or it could
And so
be
their hands are slightly tied.
they're slightly tied. Yeah, at the moment.
Yeah.
Yeah.
And so why don't you tell us a little bit about the inquiry that's currently, is currently before and that's being considered about, making changes and amendments to these sorts of issues.
Yeah, it's been a hot topic for quite a while. So there was it's a family law inquiry into the
Sure.
child support scheme, looking into various different aspects, and so there's all sorts of things that they had a look into, and they had a task force attached to it, and all sorts of things. And so there was recommendations put forward to Department of Social Services and to Services Australia, and some things were accepted, and some things were not, and those sorts of things. But there's a link between that. The one that I guess I find interesting is the link between this is not necessarily a collection topic, but between Centrelink and child support. So your
Yes.
family, if you're an eligible parent, so a person who's eligible to receive child support, and you
Yes.
might be a low income earner, and so you may rely upon the supports from Centrelink as well
Sure.
to supplement your income for your children. So family tax benefit assessments and such.
Sure.
That family tax benefit assessment is impacted by the child support assessment. So when that child support assessment goes up and down, your family tax benefit assessment goes up and down too. So they are they're seeing that there's an issue here, that really should be detached essentially. And I would
Sure.
agree with that. That's one part to it. A little bit off topic to what we were talking about. The collection side of things, though, is that there was a recent ombudsman inquiry. This was just last year, actually. This was fairly recently, where they identified that the system was being used, weaponized as a tool of abuse. And that was their
Yes.
wording. That's what they found through their
Yes.
inquiry there, financially sexual abuse was the main
Yes.
topic there. After separation, this is how the system is being weaponized in that way. So they're trying to close those loopholes that I briefly discussed before in relation to being able to access certain accounts, such as joint accounts and potentially company accounts and those sorts of things as well. And they're working quite closely with the ATO on this as well into how people are, particularly around trust, that they're sort of, I guess, running, income streams through trust and things like that. And
Yes.
they're
So
sort of
not being
looking.
able to hide.
Yeah, that's the idea is trying to sort of
Yes.
uncover those loopholes, close them up,
Or
and
pierce
make
the
a
veil,
fairer
as we
system.
say. Yep.
Yeah.
And can I ask you that in terms of, the outcome, what kind of changes or when are we likely to see these changes coming into effect?
It's supposed to be fairly soon, but I
Oh,
never.
exciting.
Yeah, I mean it's hard to tell really because the problem is there's not a lot of information published in relation to child support, unfortunately. So we really do need to do a lot of digging into this to find the information source, the information that we have to be able to provide it to our clients. But it is supposed to be all happening, rolling out this year. So we probably should start seeing
Yes.
some impacts on people's child support assessments rather sooner rather than later, I would think.
And one of the things you just touched on, and I do think it's quite an important issue, is you talked about family violence.
Yeah.
And I guess if you have somebody who comes to see you and they say to you, look, I want to make an assessment, and they have a discussion with you about options and looking at the best way to do things. Um, if they come and say to you, look, there's a history of family violence, and I am genuinely very concerned for my welfare, the welfare for my children, if I make this application. What's available to them?
It's really important that they understand what child support do because
Yes,
if they're of the, I guess, misunderstanding that it's like Centrelink,
yes,
then that's where problems can occur because they need to be aware that once you make that application to child support, they will contact the other party, make them aware that you've made this application. They will tell them how much they need to pay. They'll tell them what they'll do if they don't pay in relation
yes,
to enforcement and things like that. So it's very important that they are aware before that make that application or make that decision to make an application that you don't have to. It's always, if you're the person who's eligible to receive child support, it's always your choice how you do that, whether you do it or not. And if you do it, you can make it a private arrangement as well. So you can register a child support case and keep it non-collectible through the agency. So you can actually have a private arrangement in place where the assessment still is running, that you'll still be issued the same assessment letters as you would if child support were in charge of collecting, only the collection is managed by you. So you can do that. You can then apply for an exemption from
yes,
a social worker. All that essentially means, though, is that your family tax benefit assessment won't
yes,
be impacted by your choice not to register a child support assessment. That's really all
yes,
that means. So because if you don't, it is a requirement of Centrelink for you to
yes,
be receiving your maximum family tax benefit payment, you have to take maintenance action, which means registering a case with child support. So if it's not safe for you to do that, you can speak
yes.
with a social worker at Centrelink, let them know your situation. They'll grant you an exemption and your family tax benefit assessment will not be impacted by that. At any time, you can
Yes.
choose to register a case at child support. So whenever you feel comfortable and safe, you can make the choice to register a case with child support.
And you also mentioned about, the importance of providing information and accurate information and lots of information to Services Australia. What happens when there's incorrect information provided or inconsistent? Well, one parent says, there's no court orders or parenting plan, and they say the child's living 7-7, so equally with both parents. And the other parent says, well, no, that's actually not occurring. This is actually the arrangement. What does Services
Yeah.
Australia do in those circumstances?
That happens a lot. That's why they have the objection process at child support. So, particularly around care arrangements. So, when we talk about the change of assessment process to challenge incomes and things like that, that's one thing. But when you go through, when you register a case with child support, let them know what the care percentages are, for example. They'll check with the other party. If they agree, they'll update it. If they don't, you go on to a different area within child support, so it'll be the disagreed or disputed care team there, and they'll make a determination based on evidence from both of you. And then subsequent to that, once the decision's made, you then have your options at the ART to challenge that via tribunal hearing as well.
That's extremely helpful, and I think it's extremely important because we often, in the absence of having document, even when you have court orders or a parenting
Mm.
plan, parties may say, well, that's actually not what's happening. That
Yeah,
might be what the paper says, but it's actually not what's happening. And so it's
yeah.
really important that parties have an avenue by which they can address information that's either inaccurate, inconsistent, not correct, whether you're the paying parent, whether you're the eligible parent.
Absolutely. And keep a record yourself. So keep a care diary or a calendar because, like you say, sometimes you have a plan in place, but it's not always followed. So if you keep
Yes,
a
that's
calendar,
very good advice.
yeah, or a calendar or sort of a diary or something there, so you can provide that as evidence, essentially, if need be.
Because it can be hard to remember when you're looking backwards and you're going, okay, the order says
Extremely.
this, but so if you're keeping an accurate note or diary, whatever you want to call it,
Yeah,
and it's contemporaneous, which means, at the same time, I
yeah.
think long term that can be very helpful. A little bit tedious, obviously, for the parent to have to keep, but
It is.
important.
It is important, and we've found through those processes at objections and tribunal hearings, it's been extremely important when we're looking at evidence and you're going back, because by the time you get to tribunal, it could be a year ago that this all happened. So to actually have those detailed, calendars or diary entries or whatever it might be,
Yes.
as painful as it may be at that time of having to do that, make those, document those things, it is helpful. It can be crucial in some cases.
And so, can you take me through? I mean, one of the things I guess as a family lawyer that I get quite often is the inaccurate assessment. So, can you perhaps take us through, what's the basis of your typical standard child or the starting point for a child support assessment? And what often is inaccurate about the assessment, do
Yeah.
you find?
Yeah. So child support, how they create assessments, their administrative formula is based on both parents' taxable incomes that flow through automatically from the ATOs. So when they lodge their tax, that comes through and an assessment is made for those parents based on their taxable incomes and care percentages. So the level of care that each parent provides for their children. And they're the main components that go into that formula and create an assessment. There's other things as well. So if they have another child support case or if they have another child with another party, then that's considered as well. But that's the basics of it. So if you get your assessment or if your client gets their assessment and it's not taking into consideration, I suppose, what child support could call the special circumstances of your case, then you
Yes,
can go through what is called a change of assessment in special circumstances and what you'd know as a departure application.
sure.
And the main issue I find clients have in relation to incomes. So there's 10 reasons a
Yes.
person can actually apply for a departure, but
Okay.
reason 8 is specifically in relation to income. So for example, if someone is a business owner and they may legitimately and legally be able to claim certain aspects of their business through their tax return and it reduces their personal income down, that's fine for tax purposes. But for child support purposes, it may not necessarily be fair. So you can
Sure.
go through a review process to have a new determination made to encompass the actual income, access to financial resources, and potentially the earning capacity of that person. There's other
Sure.
reasons as well, like there could be private school fees, or it could be that your children have special needs that have a high cost. Those special needs could be braces, that could be a special talent that they have that has an additional cost attached to it. It could be travel. You could have, I guess, additional travel expenses if you're living in different states and you have to travel to see and spend time with your children. There's a variety of reasons that a person might go through that process, but I'd say the main would be the incomes.
And so when someone makes an application to review, let's say that initial assessment, one of the things that we often, when I say get complaints or concerns about more so is probably the correct word, is that, it's received and it's kind of logged into a system. And then they get told, there's going to be this significant delay period by which the review will be considered.
Mm.
And the question kind of becomes in those circumstances is what do parties do in the meantime?
And that is difficult because, like you say, no one really has control over that. The agency does have a lot of customers there and within the agency, and they are backlogged right now. They are backlogged with the change of assessment and objection processes. So it may be inevitable that you do just have that delay and you just need to wait it out. However, if you're, for example, a parent who's liable to pay child support based on an assessment that you simply can't afford because it's not correct and it's too high, you could consider applying or seeking a stay order, which is something
Sure,
that family lawyers can do. We don't do that personally here, so we would
sure.
refer you or refer the client to people like yourselves, a family law firm, to assist them with that while that matter is being dealt with through the agency.
And so when we talk about these delays, what at the moment is the average? If someone were to make an application to review, what's, the period of, the process period for that decision to then be made?
The initial stage, that change of assessment initial
Yes,
stage that I just spoke of,
yes,
generally takes about 3 months. It's usually about a 3 month process, so it's not too long. The problem
sure,
is, though, that if they go through that 3 month process and they still don't get the outcome they're wanting to achieve, so their desired outcome, they may
sure.
need to go through the next stage, which is an objections process. And then
Yes,
subsequent to that, they may find themselves at the tribunal, so the Administrative
yes,
Review Tribunal, the ART, to do a
yes,
final review of that assessment. So that whole period, you might be
sure.
looking up 12 months or so to actually get through from beginning to end.
And that's obviously can be quite difficult for parents, whether you're the paying parent who's liable to pay child support or the person receiving it. It's also got the potential to cause quite a lot of conflict between the
Yeah.
parents while this
Yeah.
is ongoing. And so, as lawyers, when people come to see us, child support for me is one of those matters that is and often when I say controversial, it's usually very important to both parents to ensure their children have what both parents had this idea that their children would have, whether that be private school or private health insurance or, all of these wonderful things that parents tend to share these common objectives.
Yes.
But the reality is like you said, with the assessment process, these things are problematic, they're difficult, there's delays, there's uncertainty. Um, in terms of alternatives, one of the things that I talk about with my clients is a binding child support agreement. And it's something that I'm quite a big fan of, which is being able to contract outside of the
Me too.
assessment
Yeah.
and to enter into a private agreement. Now, it's governed in terms of the steps required in order for enforceability. It is quite strict, but it allows parties to meet what I would say are their objectives for their children. Because you can have shared goals, but someone in some ways needs to pay for those things like private schools or the dance classes or whatever the case may be. And so we really like to, well, me personally as a family lawyer, I
Yeah.
really like to canvass those things with clients and say, well, what is it that you want to achieve? What are the common goals that you think you both can agree to? And try and lock them into what we call this binding child support agreement that ultimately locks them until the child's 18 or they complete their secondary education.
Yeah, I agree 100% with everything you just said then. I would like to see more family lawyers have that view and opinion of it as well, because you are 100% correct. While in those, particularly in those beginning stages, because a family lawyer is usually the first or one of the first points of contact that separated parents will approach. And I know a lot of parents, they generally don't see child support as being something to on the forefront. It's not something that they think about, maybe because they're not aware of it or they don't know enough about it to discuss it. So I would like to see more family lawyers bring it to their attention and have those discussions with them, like you just said, because at that point, that is crucial. Because at that point, when they're coming to see you, like you said, it's usually the time where parents are both kind of on the same page with the children being the priority, and that is their center of attention. That's what they both will usually have that central focus focus at that time. Even if they're not agreeing on anything else, they usually want what's best for their kids. But this is, I mean, like you say, it is a bit controversial to say this, but that may not always be the case. The children may not always be the number one priority for both parents, because parents, people move on. They have new families. They have a new partner that may become involved down the track in the decision making within the, within that household. And it's unfortunate and it's sad to say, but we do see that, and it's really difficult in the, down the track, 10 years time, to try and bring someone back to say, look, this is your focus. These are the children that you should be, you're focusing on, things like that. And that's when you do find conflict within the agency, is when those things happen. So if you had those initial discussions when everyone's on the same page and everyone, wants to discuss all those things that are happening right now, the private school fees and the music lessons and the sports and the, everything that you're doing right now, that's the best time to do it. And I really would like to encourage most parents to consider a binding child support agreement, to set your own terms as to what's important for you and your children, rather than following a generic assessment that's made by the government. I always say that's a safety net. That's kind of like a fallback if nothing else works. It really shouldn't be the go-to. I think a binding agreement should be the preference. That should be the first point, if possible, to negotiate.
And I think, look, as the family lawyer, when we're negotiating a property settlement, in a lot of cases, a binding child support agreement is really, really relevant. We've got kids in private school. We have
Mm,
children who might have some special talents that, require a lot more expense. In terms of sport or extracurricular activities, we may have children with additional needs.
mm,
And so, when you're setting your own terms, and we're all on the same page, it's usually, like you say, the time to do it is
yeah.
when you're trying to wrap up your whole financial relationship so that everybody has certainty moving forward. We all know that, after separation, life does move on. It's certainly my objective to keep families as intact as possible. So even though parents separate, you can still be a family. It just looks different than what it was.
Absolutely. Yeah.
And so when we have these parameters that are, very clear about what everyone's obligations are, there's no room for discussion or debate or
Yeah.
confusion. And this is what we're doing. This is what we're legally required to do. And again, in line with intentions that usually both parents have. And I think it's a really important component because the assessment, from my perspective, all the uncertainty that comes with it is a cause for major complaint. People lose their jobs and therefore the other party's assessment, the assessment changes, or the care arrangements change and therefore the assessment changes. And people will say all the time, I can't live like this. I can't budget. I don't know how much I'm getting and how much I'm paying. And they'll often say it's never enough, or how do I know what the money's being used for? And so having this sense of control
Yeah.
over it, it's like you say, setting the terms can be quite a powerful
Oh,
part of the
definitely.
financial separation process, and really, again, meet parties' objectives about what they really want for their children moving forward.
Exactly. It's tailored. It's tailored and it's more
It's tailored.
collaborative. More
Yes,
collaborative. Yeah.
I certainly agree. I guess in terms of your recommendations, if other than, of course, the binding child support agreement that we just spoke about, if parties were to separate and you have somebody who is going to make an assessment, make an application for an assessment, are there any tips and tricks that you would say that would be helpful for either the person making the assessment or the person who is the paying parent? So anything that you could recommend to the listeners today that may assist if they do go down that pathway and don't do a binding child support agreement and they go down the pathway of just doing an assessment,
Hmm.
anything that you would recommend?
It can be an easier way to go. So you're right. So if the binding agreement isn't for them, then they do have the government there. They can apply for Services Australia child support for an administrative assessment to be made. So it's important to be informed though. So I guess that's what we do, is that we do have that service there to provide clarity to customers, where we have those consults where we discuss what an assessment will look like. So if you were
Yeah.
to register a case, you know what it's going to look like before you do it. it. You know
Sure.
what things impact it. You know your options in relation to updating your own income. So you can lodge an income estimate. You might be eligible to apply to have post-separation income excluded
Yes.
from your assessment. You need to know the impact of care percentages on your assessment as well, because the
Sure.
level of care that you have of the children will impact a child support assessment also. So it's really important to have all the information first. So being informed, I think, is really important because I guess the a lot of the issues come from people being misinformed or uninformed, really, when it comes to
Yes.
child support, and having realistic expectations about what child support can and can't do, and not basing your decisions based on other people's circumstances, because you'll have a lot of well-meaning people giving you advice and information and things like that based on their own situation and their own experiences, which is fine, but that's not your situation. That's not going to be the case for you. It won't be at all. So just so that they're aware that you really need to get your own advice, your own professional information from a support team, a network of support professionals like family lawyers, consultants like us, mediators maybe, those sorts of people that we have connections with, so you can get that tailored advice for you and your kids and your family.
I think that's such an important thing about being informed. And I think this is kind of goes back to that question I was asking before, which is if you get this, assessment, are you just lumped with it? Do you have, options available to you? And I think we've spoken at length today about options for review and objections and options to resolve things amicably with binding child support agreements. And I think these are really important discussions. I think child support, as I'm sure lots of people will see in the media, can be quite controversial. It can be highly distressing for both the parent who's paying, who may feel or have the view that their assessment is incorrect, or the person receiving, who is raising children and not getting enough to put food on the table. So it is a really important, in my view, a really important area that needs attention, that needs dialogue, and that, importantly, people feel like they can get and access information, because I think it's really tricky. And I've had clients say to me previously, they've been on the phone for such a long time, or they've jumped online and they'll spend hours kind of trying to navigate, and the language is so difficult and complex, and they feel lost in this maze. And then, they're coming to family lawyers who are obviously at a very expensive price point, and of
Yeah.
course, very skilled and can give advice, but then obviously they're paying for those fees. And so we always want to be mindful of all the options that are available to clients so they can make informed decisions to move forward in their matter. And I guess, again, what I'd like to just say on that point, just because I'm such a strong advocate for it, is with binding child support agreements, I really think it's that opportunity for parties while they're negotiating their financial settlement, so their property, their assets, their liabilities, their super, their financial resources, they're able to really turn their minds to these things that are really important to both of them. That's usually, not always, but usually a very common shared objective. And so it's really, I just can't stress the importance enough that, look, it's not for everybody, and binding child support agreements aren't cheap. They do cost money, and they do require two lawyers to be involved to sign off on their the certificates of independent legal advice. However, it's a really good option if it is available. And if it's not available, to really understand that there are still options within Services Australia when an assessment is made. And I just feel so strongly about parties having information to make informed decisions, because there's nothing more important to people than their children.
Absolutely. Yeah, I agree, Lauren, 100%.
Well, Crystal, I'd like to take this opportunity today to say thank you so much for joining us. You're an absolute wealth of knowledge. I would encourage anybody who is trying to navigate Services Australia, formerly the Child Support Agency, as most people refer to them, to reach out to Crystal if you're having any issues with your assessment, or any issues navigating Services Australia generally. She is a wealth of experience. She previously worked at Services Australia for a number of years before going on her own. So I always say that no one knows it better than the internal workings than Crystal. So thank you again, Crystal, for joining us and for giving our listeners today good tips and tricks with child support and Services Australia generally.
Thank you so much. It's been a pleasure. Thank you.
Thanks, Crystal.